We do enjoy meeting with our clients at the office and enjoy the type of law we practice. But many of you may wonder, how did the practice of law, how did the law with respect to the practice of personal injury, workers' compensation originate? How did we come to be where we're at with it being a law practice here in Kansas evolving over time? With me here today to bring us some special perspective on the law and legal history is Professor Kenneth Ciboski. Professor, thank you for coming.
Thank you.
Here to discuss your perspective on the law and the history with the law. But I have a question before we get there. I was a student of yours, I believe, at Wichita State University some time ago.
It's been a while.
It's been a while, and you know, I remember
we're getting older.
We're getting a little bit older, but I remember my grade in that class was a B+, and boy, I was really having a good semester before I got that grade. Is it a little bit too late to ask you about that grade? What's the statute of limitations on that?
It's a good question. I still use the plus-minus system.
Oh, you do? Oh, well, you're one of the few probably that still do. All right, well, let's get to the serious business then. We hear a lot about jury trials and how people are afforded the right to a jury trial in this country. Well, how did that come to be?
Well, first of all, William of the Conqueror came to the area that's called England today. He won a Battle of Hastings in 1066. He took control of the church, got royal supremacy over the church. Then he began appointing the bishops. Then he sent his justices around his realm to look into the customs of the practices, the law of the day, and so on, what was going on here and so on. And then there gradually came to be what we call the common law over a period of time. The royal courts were at first not permanent features. They were gradually displaced. You had permanent courts, and then the common law system came into being. And when the king was absent, even they could have common pleas. You know, we have a common pleas court here locally, right?
Right, right.
So the common pleas idea came into being with the absence of the king, and so on. So anyhow, gradually over a period of time, then the barons to whom the lands were distributed after he conquered this area, then they had to fight the king to get their rights, what they thought they already had. So they instituted the Magna Carta in 1215 and set down their rights, you know, made sure that the king understood what they were. And then they insisted that they have a right to be tried on anything that they need to be tried on by a jury of their peers. So the jury system gradually made an appearance. It's
so
much
the
like
Magna
our grand
Carta
jury
is kind
today.
of the...
Yeah. It's much like our grand jury today. It was then, but so that gradually developed, and so the idea of the peers, you know, deciding whether you're guilty of something or not.
And back then, when they were talking about peers, they were talking about the wealthy landowners.
The barons.
The barons.
Right.
And now we talk about peers being fellow citizens.
Exactly.
In this country. You're not guaranteed a right to the same peers that you have at work, or peers as many people think of them.
That's right.
In this country, or even if you were a wealthy landowner, that doesn't mean that in this country you're entitled to a jury of other wealthy landowners. We have a jury system here, but we also have a number of other systems outside the jury system, such as the workers' compensation system, and that system came to be, I know, earlier in this century. How did the evolution with respect to workplace safety and work and the change in politics over the century bring about the workers' compensation system as you understand it?
Yeah, well, I think, you know, we had various policies passed by the Congress, you know, the legislature and so on, workmen's compensation, as you pointed out, those kinds of things, injuries that are done to people and so on, maybe on the job or whatever it is and so on, they can be compensated for that. So it was mostly a legislative policy kind of thing.
So the workers' compensation is born in basically legislative enactments, whereas the civil jury system, when say, for example, we have a tort of an automobile accident, negligence case, which is what we call a tort, that all came out of Old English law, is basically what I'm understanding you're saying.
Sure.
Okay.
Well, Roman law, you know, was important here earlier too. They got some ideas from that, and the Hammurabi Code going way back centuries.
Right.
Some ideas from that too, you know, in terms of law.
Well, the common law that you're talking about is the law basically of the courts, beginning with the courts of England then? Is
Yeah,
that-
and of the realm. What they found in the realm was common customs and practices and so on. You know, this was written down. You know, it just developed. I mean, a common law idea.
Over time. All right.
Yeah.
With respect to the American way of doing things, how is that different from, I know you've studied from the course that I studied with you, Soviet politics, for example, but
Yeah.
obviously we don't have Soviet politics per se anymore, but we have different countries around the world that claim to be democratic countries
Right.
at various levels. How does
Well, we
the
do have
American-
systems comparable to the former Soviet Union. In the former Soviet Union and China today too. There is not the presumption of innocence of an individual. If you are arrested, generally speaking, the idea is you must be guilty of something or you wouldn't have been arrested. In our system, in the English system, we have what we call the presumption of innocence. I hope it holds. I don't know. I hope that a lot of people don't think when somebody's arrested, hey, I'm sure glad they finally caught the person who's guilty.
Sure.
I think
sure.
we sometimes have that when they read the press stories and so on. I think that's a danger, you know, when it comes to this. I mean, people on the jury, you know, they're not supposed to be prejudiced with this sort of thing.
Well, what is the origin, though, of that? Very interesting that you'd bring that. What is the origin of the presumption of innocence? then?
Okay, well, going back again to about the time of the Magna Carta in 1215, they developed the idea of habeas corpus. You cannot hold a person in jail or in prison without justifying what the reason is for holding that person. You have to have a justifiable reason for doing so. You cannot arrest somebody arbitrarily. Just put them in prison arbitrarily or put them in jail arbitrarily. There's got to be a reason, and a good reason for doing so.
Okay. Well, in the context of a civil system, let's say, for example, a tort or a class action or someone filing a suit for a civil wrong, do they have any right presumptions that are common law derived that you know of?
No.
Okay.
Not in these science systems, no.
And so the burden of proof, generally speaking, in the cases, the tort cases, then is on the person that brings the claim that someone has wronged them. And do we have similar types of systems in other countries, or are we truly unique outside of England? Are we truly unique in having a civil system where rights like this can be corrected?
Yeah, the English common law system, I think, is the system that we're talking about here. In these other systems, I think you don't really have the kind of trial procedures, as I said, the presumption of innocence, and so on. So if you're arrested and you're brought in, you're probably going to be convicted of something.
All right. All right. Very interesting. Thank you, Professor Ciboski, for taking the time out of your busy schedule. I know Wichita State's getting ready to go. Good luck on your semester coming
you.
up, and thank you very
Appreciate
much.